My name is Chu Machinye, and I am your family lawyer. As always, I count it a privilege and an honor to welcome you to this episode of Your Family Lawyer, where we dissect the legal, the emotional, and human realities of inheritance and family law in Nigeria. Before we dive in, just a reminder to hit the subscribe button so you don't have to miss another episode of this podcast. If you actually care about protecting your family's future and avoiding the legal pitfalls of misadventure in family inheritance, this is the place to be. Call us right now and send us a message so that we can help you to take the right legal steps that will ensure that tomorrow and the day after will be as good as you envisage them even in your dreams. Today's episode is as dramatic as it is disturbing. We'll be exploring the uncertain and often distraught world of disinherited spouses and children. Question is, what happens when a will says no to you? In other words, when your father or your mother does not include you in his or her will. Whether by oversight, by spite, vengeance, cultural pressure, or poor planning, or even sound judgment of the testator, wills sometimes exclude those closest to the testator, the deceased. And it could be a wife, children, or both. But what does the law say about this? Whilst answering this question, we will find out whether or not a person can lawfully write off some or all of their family member from their legacy. But first, let us answer what is perhaps the most controversial aspect of disinheritance. Can a will legally exclude a spouse or a child? The answer, as you would expect, is actually that yes, the principle of testamentary freedom under Nigerian law, particularly the Wills Act of 1937 and the applicable wills laws in states drawn essentially from this. Under this, a testator has the freedom to dispose of their estate as they wish. However, this freedom is not absolute. The power to make a will is the creation of law, and every power that is created by law has its limits. The power must be exercised as prescribed by the law. I recall that Pirelli used to have an advert that said, "Power without control is nothing, absolutely nothing." Under Nigerian laws, particularly under the Wills Act and the wills laws that are applicable in many southern states, a testator has broad testamentary freedom. And this includes the freedom, the right to exclude anyone that he or she does not want from his will. Therefore, a testator can exclude a spouse, a child, a relative, or any other person from benefiting from their estate. Secondly, a testator has the freedom to gift his or her assets to non-family members. Therefore, the testator can bequeath assets to a paramour. I'm sure you ask me what it means. A secret lover, that's a paramour. She or he can gift to friends, to religious organizations, or to charity, as he or she desires. And then the motive for doing so is irrelevant. The courts usually do not inquire into the motives behind a will or the contents thereof. However, this right is not absolute. There are limits to it. The courts in Nigeria have delineated exceptions to this power in order to protect spouses and children, particularly under the following doctrines, one of which is the moral obligation that a testator owes to dependents. Where a testator had a legal or moral obligation to support a dependent, the total exclusion of such a person may be deemed contrary to public policy. And I'll just give you a simple example. If you have an autistic child whom you know is unable to cater for himself, but because you had a quarrel with the wife or you're angry that the wife bore an autistic child, you therefore exclude that child from your will. The court will look into it and favor that child. Thus, where there are moral obligations or legal obligations, a testator cannot avoid it by simply saying, I have the power to make a will. In such cases, the court will look at it and see whether that decision is contrary to public policy, just like the example I have given to you. The grounds for challenging a will by disinherited family members naturally would include some of the following. The lack of testamentary capacity. Of course, if you feel that your father didn't add you, you may need to check whether it was a girlfriend that influenced him or otherwise. Therefore, if you somehow manage to prove that the will is invalid by reason of the fact that your father wasn't thinking well or was ill at the time he made the will, of course, the court will hear you clearly. Where there is undue influence or fraud, if a person close to the testator, including that paramour I talked about, that secret lover or side chick influenced the making of the will to unfairly remove your mom and or yourself from the will, the court may take a close look to see what went down. When there is non-compliance with the formal requirements, naturally, the will be set aside. Then, of course, in cases where a custom protects assets or persons, the court may look into it. In some regions, especially under customary law or Sharia law, a testator cannot validly disinherit children or spouses without providing for them. Let me explain a little bit. Under Sharia law, there are specific quantum of your assets that you have to give to your family members. If you disinherit them, they may go back to Sharia law, make resort to Sharia law, and Sharia courts may look into what you did and ask if you were truly a Muslim. I mentioned public policy just a while ago. So in some cases, the court looks at whether what you did was reasonable or whether it was against public policy. In a certain case, the court had to invoke this public policy to invalidate a will that completely excluded the natural legal dependents. We'll talk about one or two of such cases down the line. But also, there are cases in such regions as we know in Nigeria where customary law is applicable, or where the testamentary disposition was incomplete. The duty to provide for family members may override those choices that you've made. If, for instance, the family property was involved, then the court will look at it. If you occupy a family property originally belonging to your forebears, and by reason of you being the first son, you make a will purporting to give that same property to your second wife or her son, who is your last child, the court will look at it and find a balance between testamentary freedom and legal responsibility. Islamic law also sets boundaries, as I've mentioned, for the distribution of a person's estate. If you're Muslim, it's advisable that you're mindful of these boundaries whilst making your will. Then we need to ask and answer the question, what is the impact of Matrimonial Causes Act and the Child Rights Act on disinheritance? A legally married spouse has standing under the Matrimonial Causes Act to claim maintenance from a deceased spouse's estates. And again, under the Child Rights Act, the welfare of a child is paramount, especially for minors. So yes, a will can exclude a spouse or a child, but that decision may not withstand legal scrutiny if the court finds that there was foul play, that there was bad faith, or some other mischief behind the testamentary disposition. Next, we will dig literally into the minds of the dead to find out why testators sometimes disinherit spouses or children. True, it is said the dead don't speak, but sometimes the dead speak through court decisions, through wills, and through evidential or documentary evidence that is available for us to look at. The ways in which they speak show us sometimes that disinheritance is often rooted in personal relationships, perceived or actual wrongs, disloyalty, betrayal, or shifting loyalties, or sometimes the overarching commitment of a patriarch or matriarch to protect the estate from wasteful or irresponsible children, or even wayward spouses. But not every emotional reason holds water in law. Let's look at some of them. And they include adultery or marital infidelity. Quite often, testators disinherit spouses for perceived or real infidelity or adultery. Whilst morally weighty, adultery is not an automatic ground for lawful disinheritance unless it was judicially determined and the marriage was dissolved. You may forgive me if you don't agree with me, but that's what the law says. Even then, even when adultery is proven and the courts have dissolved the marriage, the court may still uphold a widow's rights to inheritance where she remained financially dependent on the deceased, or where she was legally married to the testator until the time of his death, even though she was adulterous. We also find that one other motivation for disinheritance of a child includes estrangement from the parent, misconduct or waywardness, addiction to drugs, persistent disrespect or protracted family disputes, which often lead to these children being disinherited. Nigerian laws allow testamentary freedom, but courts may intervene where the child is a dependent or if exclusion leads to destitution. Unlike the father in the prodigal son's story, testamentary benefactors are not known to take kindly to irresponsible lifestyle of spouses or children, and often do not happily pass on their wealth to black sheep in the family. That child who gave his father heartache, refused to go to school, or often in and out of rehab, is unlikely to be entrusted with the family wealth. If you are a disrespectful, contentious, and nagging wife, for whose sake your husband is hypertensive, he may remember your disservice and disloyalty and pay you back in his last act of vengeance. So whilst your husband or wife might irritate you now and again, farabale, because in truth, whilst marriage lasts, we all somehow manage to irritate each other once and again. But it is for a lifetime. It is till death do us part. So enjoy it while it lasts. Do not forget to click the subscribe button and turn on your notification bells for more interesting episodes. And for legal consultations or legal advice, please call the number on your screen or send us a WhatsApp message. Until then, please stay informed and be empowered. And by all means, be good to your family. My name is Chuma Chinye, and I am your family lawyer.